Hello friends, today my topic is about the nature and scope of Directive Principles of State Policy. Introduction. The founding fathers of Indian freedom movement, right from the beginning of the battle to the overthrow of the British Empire, envisioned a comprehensive conceptualization and articulated the demand for freedom in its political, economic and social dimensions. The leaders of India's freedom movement visualized that in the new dispensation following political freedom, the people should have the fullest opportunities for advancement in the social and economic spheres, and the state should make suitable provisions for ensuring progress. Thus, the framers of the Constitution of India, in its preamble, promise social justice to every citizen. If the preamble is the key to understanding of the Constitution, the directive principles of state policy are its basic ideals. One of the distinctive features of Indian Constitution is the inclusion of the directive principles of state policy. Borrowed from the Irish Constitution, the makers of our Indian Constitution incorporated these principles in Part 4 of the Constitution from Article 36 to Article 51. These principles were deemed fundamental in the governance of the country, which epitomized the hopes and aspirations of the Indian people. Now, let us discuss about the meaning of Directive Principles of State Policy. The Directive Principles of State Policy, embodied in Part 4 of the Constitution, are directions given to the central and state governments to guide the establishment of a just society in the country. The directive principles are affirmative instruction to the state authorities to secure to all citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. These principles underline the philosophy of democratic socialism and to secure the high ideals set forth in the preamble to the Constitution. It is the duty of the state to follow these principles both in the matter of administrations as well as in the making of laws, because the basic aim of directive principles is to establish a welfare state where economic and social democracy might flourish. The directive principles are embedded as integral part of our Constitution, and that these now stand elevated to the inalienable fundamental human rights. Now, let us discuss on the nature of the directive principles of state policy. The directive principle of state policies aim to create social and economic conditions under which the citizens can lead a good life. The directive principles of state policy possess two characteristics. Firstly, they are not enforceable in a court of law, and therefore, if a directive is not obeyed or implemented by the state, its obedience or implementation cannot be secured through judicial proceedings. Secondly, they are fundamental in the governance of the state, and it shall be the duty of the state to apply these principles in making laws. Directive principles of state policy aim to create social and economic conditions under which the citizens can lead a good life. They also aim to establish social and economic democracy through a welfare state. They act as a check on government, theorized as a yardstick in the hands of the people to measure the performance of the government and vote it out of power if it does not fulfill the promises made during the elections. Since the directive principles are not enforceable by court, it has been advocated that they are not law, and therefore their non-observance by the state does not entail any legal consequences. Merely because the directive principles of state policy are not enforceable in a court of law does not mean that they cannot create obligation or duties binding on the state. The crucial test which has to be applied is whether the directive principles impose any obligations or duties on the state. If they do, the state would be bound by constitutional mandate to carry out such obligations or duties, even though no corresponding right is created in any one which can be enforced in a court of law. In the case of State of Madras versus Champakam Dorairajan, the court held that the directive principles of state policy have to conform to and run as subsidiary to the fundamental rights because the latter are enforceable in the courts while the former are not. But this view has been contested from the very beginning on the ground that being part of the same constitution, fundamental rights and directive principles are equally important and neither of them is superior or inferior to the other. Rather, both supplement each other and have to be construed harmoniously. Now, let us discuss the scope of the directive principles of state policy. The directive principles of state policy may be classified under several groups. First, socialist and economic principles. The socialist and economic principles always aim to save our country into a welfare state. Article 38 Clause 1 provides that the state shall promote the welfare of the people by securing and protecting as it may a social order in which justice, social, economic and political shall inform all the institutions of national life. The state shall strive to minimize the inequalities in income and try to eliminate inequalities in status, facilities and opportunities among individuals and groups engaged in different locations within the country. Thus, promotion of welfare of people by securing a social order where justice shall prevail in the objective of our Constitution. To ensure such objectives, the state shall direct its policy in securing adequate means of livelihood for all citizens irrespective of men and women equally. Equal distribution of wealth and resources among all classes, equal pay for equal work for both men and women, just and human conditions of work, a decent standard of living, full employment, leisure, social and cultural opportunities, participation of workers in the management of undertakings and establishment, protection of children, youth against exploitation and against moral and material abandonment. The 42nd Amendment altered these provisions and provides that children are given opportunities and facilities to develop in a healthy manner and in condition of freedom and dignity, and that childhood and youth are protected against moral and material abandonment. Provision of work and compulsory education for all people, relief in case of unemployment, old age, sickness and disability, and other cases of undeserved want. Equality of opportunity and status for all individuals, level of nutrition and standard of living of the people, public health and enforced prohibition of consumption of intoxicating drinks and drugs, environment, safeguarding forests and wildlife of the country, a uniform civil code throughout the country, and protection of adult and child labor. Second, the Gandhian Principles. Principles enjoined under Gandhian Principles in Article 40, Article 43, Article 47 and Article 48 are some ideals of Mahatma Gandhi followed during his lifetime. Our Constitution framers wanted to implement these ideals to fulfill his dream. The state shall take steps to organize village panchayats and endow them power and authority to enable them to function as unit of self-government. to promote cottage industries and village industries on an individual or cooperative basis in rural areas, to prohibit consumption of intoxicating and injurious drinks and drugs, to promote educational and economic interests of the weaker sections of the people, particularly scheduled castes, scheduled tribes, to establish social justice and equity, to organize agricultural and animal husbandry on modern and scientific lines, to prohibit the slaughter of cows and other useful cattle, to protect and improve environment and safeguard the forests and wildlife of the country, to protect, preserve and maintain places of national historical importance, to separate the judiciary from the executive. Third, international principles. Principles enjoined in Article 51 under international principles are some provisions to the state relating to ensure international peace and security. The state shall attempt to promote international peace and security, to maintain just and honorable relations between nations, to foster respect for international law and treaty obligation, to encourage settlement of international disputes by arbitration. By the 42nd Amendments, certain changes have been introduced in the Part 4, adding new directives to accentuate the socialistic bias of the Constitution. Article 39A has been inserted to enjoin the state to provide free legal aid to the poor and to take other suitable steps to ensure equal justice of all, which is offered by the preamble. Article 43A has been inserted in order to direct the state to ensure the participation of workers in the management of industry and other undertakings. Article 48A has been inserted in order to direct the state to promote and improve the environment and to safeguard the forests and wildlife of the country. Clause 2 has been inserted in Article 38 by the 44th Amendment Act 1978 as follows. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities not only amongst individuals but also amongst group of people residing in different areas or engaged in different vocations. Next, let us discuss on the implementation of directive principles of state policy. The Constitution framers enshrined so many principles in order to establish a new social order in which justice, social, economic and political shall prevail. To fulfill basic objective, the state has been charged to make effective provisions for securing the right to work, to education, and to public assistance in case of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. To implement and translate such directives into action, the government has taken so many steps colored by these directive principles. The government has enacted social, labor, and economic legislations, besides industrial, agricultural, and taxation policies. For example, the Taxation Inquiry Commission 1953-54 was asked to examine the tax structure and to suggest measures to reduce the inequalities of income and wealth and some other related subjects. The Industrial Development and Regulations Act 1954 and establishment of the Monopolies Inquiry Commission in 1965 were aimed to achieve the objective outlined by the Taxation Inquiry Commission. In the early years of the 1950s, land reform legislation was enacted to abolish intermediaries and zamindari system, and now land, both rural and urban, is subject to ceilings, and the surplus land has gone to the weaker sections of the community. A large number of laws have been enacted to implement organization of village panchayats as a unit of self-government, which has been enshrined under Article 40. All over the country, and especially the government has enacted the historic 73rd and 74th Constitution Amendment Act 1992 to build Panchayati Raj institution as an administrative unit. For the promotion of cottage industry, steps has been taken to encourage the masses. Besides, the government has established the All India Handicrafts Board, the All India Handloom Board, the Small Scale Industry Board, the Silk Board, the Coir Board, etc. for promotion of cottage industries. The National Small Industries Corporation, the Khadi and Village Industries Commission have been set up for the development of the Khadi and village industries. Various measures including employment generation schemes have been undertaken to promote and uplift of scheduled castes, scheduled tribes and other backward classes. Legislation for compulsory primary education, Article 45, has been enacted. For raising the standard of living, Article 47, the Government of India adopted the first ever large-scale program called Community Development Project in 1952 for rural reconstruction in the field of communication, transport, housing facilities, sanitation, agriculture, education, etc. Regarding prohibition of intoxicating drinks and drugs, Article 47, most of the states has enacted legislation and imposes some restrictions on it. Necessary legislation has been enacted to protect places and monuments of national importance. And to the separation of the executive from the judiciary, Article 50, most of the states have taken legislative measures. The Government of India has enacted the National Rural Employment Guarantee Act to ensure 100 days work assistance to rural people, which is in conformity to the right to work enshrined in the Directive Principles of State Policy of the Indian Constitution. Next, let us discuss on the sanction behind the Directive Principles of State Policy. The Directive Principles have been criticized as not binding since they have been declared not enforceable by the courts. This aspect of the matter was explained by Dr. Ambedkar when he observed during the Constitutional Assembly debate that although there is no sanction against the state in the legal sense, if it does not implement these directives, the state would be answerable to people every time at the time of elections, and people would reject the government, which did not take steps towards the implementation of these directives. It has been considered as an effective sanction against the state in Constituent Assembly. Therefore, there may not be the legal force behind the directives, but the highest tribunal, the public opinion, stands behind them. To conclude, the Directive Principles have great constitutional significance. They have been declared to be fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Though these principles are not enforceable in the courts, yet no government would dare to ignore them. Every government should take steps for implementing Directive Principles of State Policy as far as possible, or else it would be criticized on the ground of non-fulfillment of the directives. It cannot be denied that the directives are part of the Constitution as much as the mandatory provisions. It follows that according to the rule of harmonious construction, on all parts of the Constitution must be read together so that in the matter of interpreting the mandatory provisions, the court cannot ignore the directive principles. Though these are not cognizable by the court, and if the government of the day fails to carry out these objectives, no court can make the government implement them. Yet, these principles have been declared to be fundamental in the governance of the country. Thank you.